Absolutely a danger to the community. He likes beating up people who might get him in trouble. We would ask that he be held without.
Okay, and Mr. Perney, it's generally my starting point. I mean, I understand it's not like a policy. I do make exceptions to it, but my starting point is if you're on felony probation with me and you're alleged to have committed another felony, you don't actually have the right to be released. What you do have a right is for me to hold the contested hearing within 14 days. So if you insist, I'll certainly do that. But I am at this point not going to release Mr. Marino until further order of the court.
What you're about to see is a masterclass in how fast a courtroom can turn ice cold. This hearing doesn't start with shouting or theatrics. It starts with procedure. But don't let that fool you. Because buried inside routine language are some serious red flags. Probation violations, a fugitive pickup, alleged assault, and claims of evidence tampering. And all of that is standing between one man and the possibility of walking out free. This is the state of Michigan versus Jacob Vincent Marino. And the key thing to understand right now is this. He's not starting from neutral. He's already on felony probation. That changes everything. Probation isn't a fresh slate. It's conditional freedom. And when those conditions are allegedly broken, the court doesn't need proof beyond a reasonable doubt. The bar is lower, the consequences are faster, and the judge's discretion is broader. Judge Gauthier, a male judge known for being direct and methodical, makes one thing clear early on. Probation is not a right. It's a privilege. And once new allegations stack up, especially violent ones, that privilege can disappear in seconds. As you watch this unfold, pay close attention to how calm language carries heavy consequences, because one sentence in this hearing seals the outcome.
Handling Mr. Marino and Ms. Poliandro, it's you, right? Do we want to bring her up in person? Is she in the jail?
She's in the jail.
And then Mr. Marino's in the jail too. Are you doing that arraignment?
I could, but I'm an attorney. I was set to arraign him on another case last week, and
Eric Perney was his retainer. So you think Perney might
he
appear
might.
today?
Otherwise, I would have to have a small discussion. I'm aware of the probation. It's a probation violation, is it?
Yeah. So we've got Mr. Perney zooming in. All right, up next, we've got People of the State of Michigan versus Jacob Vincent Marino, file 24-93301FH for an arraignment on a probation violation warrant. Counsel, you want to state your appearances, beginning with the people.
Jeremiah Buffalo, we're on behalf of the people.
Hey, good morning, Your Honor. Eric Perney, on behalf of Mr. Marino, P79467.
All right, good morning. And Mr. Perney is zooming in, and Mr. Marino is appearing by video from the Prescott County Jail. Let me know, Mr. Perney or Mr. Marino, at any time if either of you desire a breakout room, and I can facilitate.
Sure, thank you.
All right, so Mr. Marino, it's alleged that you're in violation of your probation in four counts. Count one alleges that since your placement on probation on October 7th of last year, you have left the state of Michigan without consent of the court. Count two alleges that since your placement on probation, you have used and or possessed alcoholic beverages. And count three alleges that on or about July 7th, you engaged in assault of this year, 2025, you engaged in assault of abusive, threatening, or intimidating behavior against one Brooke Mishley. Count four alleges that in violation of condition one, you violated the criminal law by committing an assault against that same person. You have the right to have a hearing on these allegations where they would need to be established by a preponderance of the evidence. You have the right to the assistance of your attorney, and Mr. Perney's here representing you. If you couldn't afford an attorney and petitioned, you could be eligible for an attorney at public expense. You have the right to present evidence at that hearing and to cross-examine any of the witnesses presented against you.
This is where the hearing quietly becomes dangerous for the defendant. Judge Gauthier lays out 4 alleged probation violations, and while they may sound similar on the surface, legally they are not equal. Counts 1 through 3, leaving the state without permission, alcohol use, and alleged threatening behavior, are considered technical violations. Those usually come with capped jail exposure, especially for a first-time technical offender. But count 4, that's the landmine. A non-technical violation tied to a new criminal offense. And that distinction matters because it opens the door to full probation revocation. Translation, The judge could sentence Mr. Marino on the original felony, fleeing and eluding, with up to 2 years in prison. No jury, no trial on the probation case, just a finding by preponderance of the evidence. This is why defense attorneys take probation violation hearings so seriously. You're not just defending against accusations, you're defending your client's freedom on fast forward. So here's the question for viewers. If you were already on probation, how careful would you be knowing one mistake could erase everything?
You are on probation to me for a charge of fleeing and eluding in the 4th degree. That is a maximum penalty of 2 years in prison. Count 4 is a non-technical violation, meaning if you are found to be in violation of count 4, then I could revoke your probation and sentence you on that underlying offense. Counts 1, 2, and 3 are all technical violations. Those being separate technical violations, that would mean that as long as you have no prior technical violations, which I think you don't have, that would be a maximum exposure for 15 days in jail for a first technical, 30 days for a second, 45 days for a third technical. Mr. Marino, do you understand the maximum penalty that you could face and the rights that you have in this matter?
Yes, Your Honor.
And Mr. Perney, do you know how he wishes to plead?
Yes, Your Honor. Thank you. My client will stand mute and ask the court to enter a not guilty plea for those violations.
Okay, we'll enter a plea of not guilty and schedule this for a probation violation hearing. Do you know, Mr. Perney, have there been criminal charges filed as a result of any of these allegations?
Yes, Judge. So I was appearing before the court with Mr. Marino last week. There was a felony complaint and warrant issued last week at some point. He was arraigned, I believe it was Thursday or Friday of last week. He was issued a $15,000 cash surety bond. The judge did order, if he was able to get released, that he could that you had to have a tether placed on him. During that time, Your Honor, we did waive the 21-day rule at the time of his arraignment. So they did schedule a PCC on or about August 20th, I believe it is. So we have a few weeks before that PCC date. With that said, I'm not sure if the court's so inclined to allow us to, because the 4th count that you just mentioned in the record, obviously, is the most severe, and that's what we're going to court on in August. If you could mirror or give him a personal bond on this one so that he can meet with me, and then we can come back after our PCC date if possible.
Okay, I could schedule this for a probation violation hearing on September 8th. My August date is August 11th, so that would even predate your PCC. So it makes sense to maybe put this on the September docket then.
Okay.
We could schedule that for 11 a.m. And Mr. McLennan, as to any pretrial release on the pending probation violation, what's the people's position?
If I may, Your Honor, I would like to note that as to that count 4, we also have an allegation and a charge pending of tampering with evidence relative to evidence of violations in this instant hearing, Your Honor, or in this instant case. So, Your Honor, we have him tampering with video evidence that equals a probation violation. We have him here on an underlying case of fleeing and eluding, and we had to send our fugitive task force team to go find him for the new cases. Your Honor, he's absolutely...
This is the turning point, and the prosecution knows it. When the state raises allegations of evidence tampering and says a fugitive task force had to locate the defendant, they're not just arguing facts. They're framing risk. Courts don't only weigh guilt here. They weigh danger, flight, and credibility. And when a prosecutor uses words like tampering and fugitive, that sets off alarms. Judge Gauthier's response is telling, calm, measured, and absolutely firm. He doesn't raise his voice. He doesn't lecture. He draws a line. If you're on felony probation and you're alleged to have committed another felony, release is no longer the default. The right you retain isn't freedom, it's speed. A prompt hearing. That's it. This is judicial authority at work. No theatrics, just consequence. And when the judge says he's not going anywhere, that's not opinion. That's policy backed by law. So ask yourself, should courts be stricter with probationers accused of new crimes? Or does this system move too fast?
He's absolutely a danger to the community. He likes beating up people who might get him in trouble. We would ask that he be held without.
Okay, and Mr. Perney, it's generally my starting point. I mean, I understand it's not like a policy. I do make exceptions to it, but my starting point is if you're on felony probation with me and you're alleged to have committed another felony, you don't actually have the right to be released. What you do have a right is for me to hold the contested hearing within 14 days. So if you insist, I'll certainly do that. But I am at this point not going to release Mr. Marino until further order of the court. And we'll schedule it for a probation violation on September 8th at 11 a.m.
All right, very good.
Okay, have a good day.
You too.
Conclude your matters, then, Mr.
That concludes my matters this morning.
All right, Mr. Vogler, you ready on Ms. Parr?
Yes.
This is People v. Andrea Parr, file 25-93352FH. We've got Ms. Parr present in the courtroom with her lawyer, Mr. Vogler. We've got Mr. McClellan for the people. And, we're here, it looks like we had I did have a consultation with counsel about this. That's right. So we're here for the plea taking today. And Mr. McClellan, do you have an amended information?
Yes, Your Honor.
Mr. Vogler, do you consent to its filing?
Yes, Your Honor.
Would you please raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down. Ms. Parr, a guilty plea hearing it's a very important event because you waive rights that you have. So listen very carefully. If you have any questions for me, go ahead and answer them. We're happy to go ahead and ask the questions. We're happy to answer them. If you need more time to talk to Mr. Vogler, you just let us know anytime, right?
Okay.
Now, I have to advise you the maximum penalty that you could face for count 3, possession of methamphetamine. It is a felony. It's punishable by a maximum of 10 years in prison and or a $15,000 fine. Do you understand that maximum penalty?
Yes, sir.
All right. And are you on probation or parole anywhere?
No.
Were you on bond for any other case at the time of this incident?
No.
Did you read and understand the rights listed on the advice of rights?
Yes, sir.
And you signed that form today?
Yes.
Do you have any questions for me or Mr. Vogler about any of those rights?
No.
Do you understand that by pleading guilty, you give up all those rights?
Yes.
And is that what you're choosing to do today?
Yes.
If I accept your plea, you give up any claim that it was caused by any threats or any promises that aren't placed on the record. Do you understand that?
Yes.
Also, you lose the right to appeal. And if you want to appeal, you have to seek permission by filing an application. The types of issues that you could raise on that appeal after pleading guilty are very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes.
The plea agreement provides in exchange for your plea of guilty to the added count of possession methamphetamine, the prosecutor is going to dismiss the first 2 counts. And there's a sentence agreement that you be sentenced pursuant to section 7411 of the Public Health Code. Do you understand the terms of that agreement?
Yes.
So that means it'd be a non-public probation. If you successfully complete probation, then the charge is dismissed. There's no public record of the conviction. Do you understand that?
Yes.
Mr. Vogler, is that a full, fair, and accurate statement of the terms of the agreement?
Yes.
Mr. McClellan?
Yes.
All right, Ms. Parr, that sentence agreement for 7411 is not binding on me, meaning at sentencing, I wouldn't have to give you 7411. But if I didn't, you could withdraw your plea because you wouldn't have gotten what you bargained for. Do you understand that?
Yes.
There is an important exception to that, however, if you engage in some misconduct between now and sentencing, say by skipping court, absconding your bond, committing a new crime, or violating your bond. Any of those things would cause you to lose the right to withdraw your plea, even if I did not give you the 7411. Do you understand that?
Yes.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No.
Has anybody threatened you to make you do so?
No.
Is it your own free choice to enter that plea?
Yes.
Knowing all this, how do you wish to plead to the charge of possession methamphetamine?
Guilty.
So back on March 6th of 2024, were you within Presque County?
Yes.
And did you at that time have possession of the controlled substance methamphetamine?
Yes.
Did you know that you were in possession of it?
Yes, sir.
And did you have any lawful authority to possess it?
I'm sorry.
Did you have any lawful authority to possess it?
No.
Mr. Vogler, you satisfied with the factual basis?
Yes.
Mr. O'Connor?
Yes.
And Mr. Vogler, are you
Notice how different this feels. Same courtroom, same judge, completely different tone. This isn't confrontation, it's precision. Judge Gauthier carefully walks Andrea Parr through her rights, her risks, and the limits of appeal. The maximum penalty hangs heavy, 10 years, but so does opportunity. Section 7411 isn't a free pass. It's a conditional second chance. Legally, this is significant. A 7411 disposition means successful probation could erase the conviction from public record. But listen closely to the warnings. One misstep, one violation, and that deal evaporates. The judge makes it clear, this isn't about sympathy, it's about compliance. This moment shows the court's dual role, accountability and rehabilitation. Two defendants, two paths, one fighting detention, the other walking a tightrope toward a clean slate. Same system, wildly different outcomes. So here's the question. Should second chances like this be more common or more rare?
aware of any other promises, threats, or inducements?
I am not.
Do you believe I've complied with 6.302?
Yes.
Mr. McLennan, do you agree on both counts?
Yes, Your Honor.
All right, and Ms. Parr, I find therefore that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense, so I hereby accept your plea. We'll schedule sentencing for September 8th, 9:30 in the morning. You'll have to cooperate with a pre-sentence report, so I want you to see if you can get contact information from Agent Lesky today, and then you'll have to reach out to her to schedule an interview so she can prepare a report for me to make some recommendations about a proper sentence. You have to cooperate with that process. Any objection to continuation of bond?
No, Your Honor.
We're going to continue bond, and what I'll do, Mr. Vogler, I'll also continue the pending bond violations alleged for a status conference on the sentencing date, and I'll just indicate if there's no further violations between now and then, I'll just dismiss them at that point.
Yeah, just so the record's clear on that, so my client currently goes to a methadone clinic where she is tested twice a month. I believe it's random, right?
Was once a month.
But now it's twice.
I asked for it to be more, for twice a month, yes.
And that's totally random.
Yes,
You never know when
Yep.
you're getting tested.
no,
So is that sufficient that what we're doing there and we're getting the reports?
Well, except random in terms of the times that she is going to the clinic.
I think she goes every
I
day.
go daily,
Oh, you go daily?
Yeah.
They do daily administration.
yeah.
Are we getting copies of those though?
The only day they're closed is Sundays.
I've been providing them to the
You've been
prosecutor.
provided.
Yes.
So, and this has been a situation from the very beginning, regardless of what the bond condition said. She talked to, it was Colette at the time. As long as she's being tested there, she didn't have to call in. She never called in. She's always been tested there. There's never been any problems.
Okay, I'm going to dismiss the pending show cause then. Just keep doing that. We won't do a whole new bond set of paperwork. Just keep doing that. All right, so we'll see you September 8th at file 25-7036FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
No, not guilty here from Miss Burgess, who appears in person to my right in custody.
All right, we're here for sentencing, the jail contraband habitual third with a 10-year maximum, some misdemeanors as well. Guidelines for scored at 0 to 13 months. If you have a chance to review the report and recommendations.
Have your honor.
Any additions, corrections, or scoring challenges?
One correction just as to credit time. It has her credit time through June 25th. She did become incarcerated again on July 30th, today's date. So that would be, I think, 14 additional days.
Okay, for a total of 56 then?
Correct.
Okay. All right. Any scoring challenges?
No, your honor. And she advises everything else looks correct.
Goodrich, any additions, corrections, or scoring challenges?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. So Ms. Burgess comes before the court at 37 years of age. She is, although she's had a recent sort of slip up here, getting into recovery court, does advise that she's actually committed to continuing the program. She thinks this is going to be great for her and her small child. She is employable, and I think employed when she's out of custody. I think she's got a bright future going forward as long as she can stay on the straight path here. She is committed to doing that. I think she's going to be moving out of the residence, which she was staying, which I think had some contributing factors here to why she's appearing in front of the court today in orange. We are going to ask to have her admitted into the recovery court program. It sounds like all parties involved, at least that I've been able to speak to this morning, are on board with that. She's very much on board with that still. And so that's what we want the court to do today, is just to adopt the party sentencing agreement for Sheboygan County Recovery Court. I don't believe that Ms. Burgess wants to make a statement today, but I would, I guess, also highlight for her on her behalf that although she had this slip up, it seems like she was very honest about what was going on and pretty forthcoming. I don't have any other information that indicates otherwise, at least. So I think that she's going to continue to be a good candidate and is committed to doing this right. Thank you.
Okay, thank you. Ms. Burgess, you don't have to tell me anything today, and if you choose not to do that, I don't hold that against you at all. But you are allowed to say anything if you wish. Is there anything you want to say or no?
No, Your Honor.
Ms. Goodrich, any recommendations?
Your Honor, I continue to be in agreement with recovery court for Ms. Burgess.
All right, Ms. Burgess, if you want to please stand for the first sentence. Ms. Burgess, you're 37 now. You've got 2 prior felonies, 5 prior misdemeanors. I've had you on probation before, and it went very badly because of your failure to comply. So in this case, I think that even though these guidelines are not, they're at 0 to 13, this would be unlikely to be a prison case for you. We normally like to take prison presumptive cases into recovery court and reserve the spots for that. But the extent of your substance abuse struggles and the lack of progress on regular probation made us think that your application into recovery court was appropriate, that you need a more intensive probation. You did have some issues starting out, but if you're honest with what's going on, I think we'll do everything we can to try to help you navigate these struggles that you've had. But I need you to know you can't just do things the way you want to do them, which is how you and I have operated that way for a while. I've had you on probation before, and that hasn't seemed to bother you to do what you want, go where you want, do the things you want, ignore the things you want. Me being a judge with a probation order over your head hasn't seemed to affect your behavior at all. If that continues, you're not going to finish this program. Honestly, only about half the people that enter the program graduate from it. The ones that do are the ones that honestly want to do it for themselves. But those are the only ones that make it across. So only you know if you're in that category. I hope you are. In this case, you were driving while high and gave the police a fake name. You didn't have a driver's license, and then when you got to the jail, you had some drugs you were gonna take with you into the jail. So that's all, bad behavior that puts you and other people at risk out in the community, on the roads, and in the jail. Even with the 0 to 13, you would certainly be getting some jail from me. But I think you're appropriate for this treatment court program. Based on my review of the file and the pre-sentence report, I find under the applicable statute that Ms. Burgess is or was dependent on or abusing drugs or alcohol, and she's an appropriate candidate for participation in the treatment court program. I find that she understands the consequences of entering into that program and has agreed to comply with its requirements. I find that Ms. Burgess is not a violent offender, and she doesn't pose an unwarranted or substantial risk to the safety of the public or any individual based on the information available to me from our pre-sentence screening and pre-sentence report. Therefore, I find that she is appropriate for treatment court, so I will sentence her accordingly to probation on the felony charge for a term of 30 months, subject to the terms and conditions listed on page 3 and 4 of the pre-sentence report. That includes all the conditions on there. The principal term is that you comply with and graduate from the Sheboygan Recovery Court program. I'll also order that you serve on that charge as well as on the misdemeanor charges, 56 days in jail, and give you credit for 56 days previously served. There is on this judgment going to be state costs totaling $218, crime victims assessment of $130, court costs of $350, a $600 recovery court participation fee, and $141.08 for an OUIL reimbursement. That is a sentence within the advisory guidelines. Ms. Burgess, if you wish to appeal, you can do so by filing an application. If you wanted a lawyer, you'd have to ask us within 6 months. We're going to hand you a piece of paper explaining that process and ask you to initial one copy for us, so we have a record we gave it to you. The other one is for you to fill out if you want to take an appeal. You should get the paperwork done to get you out today, and then you need to stop by and see Nicole today. You have any questions for me?
No, Your Honor.
Okay,
Thank you for the opportunity.
Okay, I'll see you tomorrow.
This courtroom session tells 3 very different stories, all under the same roof. Jacob Marino's case shows how quickly probation can collapse when new allegations pile up, especially violent ones. Judge Gauthier makes it clear, probation is conditional freedom, and once credibility and safety are questioned, detention becomes the default. The ruling isn't emotional, it's structural. Andrea Parr's plea highlights controlled mercy, a calculated second chance under strict legal boundaries. And Miss Burgess's sentencing underscores accountability with structure. Recovery court, jail credit, heavy financial obligations, and an unmistakable warning that only effort earns success. Judge Gauthier doesn't sugarcoat outcomes, but he leaves the door open for change if the defendant walks through it. 3 defendants, 3 paths, 1 courtroom reality. The law rewards responsibility and punishes risk. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.